I'm Lucy Beednell with the ARC of Northern Virginia. This 3-minute webinar is going to give you some quick tips and things to think about that you may not have considered if you're getting a divorce and you have one or more children with disabilities. Disability adds another layer of complexity to existing divorce considerations. Obviously, you'll be going through the same process that anyone else with a divorce is, but there's some other things to take into account. First of all, make sure you're asking right up front if the family attorney with whom you're working has any experience with people with disabilities, navigating public benefits, special needs trust, those kinds of things. Small changes in wording can make a big difference in how things end up playing out. So you want to make sure that you're working with someone who knows what they're doing. Next, Virginia passed a law, Connor's Law, in 2015 that allows for child support to be paid if parents divorce after a child is 18, but that child has a disability that's going to require them to have ongoing funding and supports. So make sure you're asking for that funding, and if you are divorcing when your children or child with a disability is under the age of 18, make sure that the wording ensures that child support continues after that person becomes a legal adult or until you expect they will no longer need additional support services related to their disability. Special needs trusts are a big thing to consider. If the person with the disability is going to be receiving child support, you can look at putting it directly into a special needs trust rather than to their bank account. That means they would still be eligible for programs like Medicaid, Medicaid waivers, Social Security, etc., when they're adults or children, because income and assets for kids are considered in those situations. Lastly, let's talk about educational decision-making authority. So educational decision-making authority often means that in Virginia, either or both parents, regardless of the custody agreement, can make sole educational decisions, meaning a parent who has no legal custody could still make all the IEP decisions if they were the parent who was contacted and signed on the dotted line. So in your court agreements, make sure you decide if one or both parents are going to have sole educational decision-making authority and how exactly that's going to play out. And bear in mind that the parent who doesn't have decision-making authority can still be mandated to be jointly notified about meetings, to be present, and to participate in any other ways that you think are critical. You can reach us anytime at thearcofnova.org and ask us questions at thearcofnova.org/answers. You can learn about supported decision-making, a critical tool for empowering people with disabilities during all times, especially through a divorce, and visit our Transition Points toolkits, guides, and webinars, which help you provide information for people with disabilities across a lifespan in all circumstances. We look forward to working with you. Have a great day.